Good morning, everyone, and welcome to Professional Insights, brought to you by the National Referral Network. This is where we bring you professional insights from professionals regarding things like, well, they're finance related, business related, and we bring them to you every week so that you can use them in your businesses, learn a few things, and all that good stuff. Today, I'm with Keila Nakasawa. Did I pronounce that right? I'm talking
Yes.
enough that okay. I'm glad I did it. You got to get the name right first, right out of the box. Keila is a Beverly Hills estate planning attorney. That sounds really prestigious, by the way. I am a Beverly Hills estate planning attorney. She's been in practice quite a number of years. Won't say how long, but let's just say you're seasoned. You've been around the block a couple of times, okay? And we're going to talk about estate planning, and in particular, some of the things that are often, I guess, misunderstood, some of the things that maybe people get wrong in their approach, and how maybe you can approach the process so that you get your money's worth out of the person you're talking to. So, Keila, thanks for being here. Want to jump right into this. What are some of the more common mistakes you see people make when approaching their estate planning?
I think that one of the mistakes that I see is naming co-trustees.
Oh,
So, for example, a mother would name two of her daughters as co-trustees,
okay.
and that's very problematic. Now, I know that other attorneys would do that, but I would not do a co-trustee. So
Now,
if somebody comes to me and they want to do co-trustees, I'm going to say I'm not going to do that.
wow. So you just so let's walk down that road for a second. So why is it a bad idea? Let's say somebody has two kids and you don't want to slight one over the other. Well, they can both do it. Why is that a bad idea?
So when the parents are alive, they get along fine. But after they've passed, it always becomes a problem because co-trustees, they have to agree on everything. So the case that I did is so one sister lived in Los Angeles County and the other lived in Riverside County. So Riverside and Los Angeles, they're about 3 hours apart.
Right.
And the property was located in Los Angeles County. And the sister who lived in Los Angeles County had her adult son lived in the property rent free. And
Hmm.
they couldn't agree on anything. They couldn't agree when to sell. They couldn't agree on the real estate agent. They couldn't agree. So it ended up in litigation. So that's what co-trustee. So that's not the only situation that I've seen where co-trustees end up in
So
litigation.
when it went into litigation, though, what actually happened? How much did it cost the estate, and what was the end result?
So it probably took about 3 years in litigation, and I can't remember exactly how much, but it cost a lot of money, and they bickered over everything. They couldn't agree on anything, and it just ended up in just costing them a lot of money, a lot of time, and just frustration. So
So,
I wouldn't do co-trustees.
So if there was one trustee, if they weren't co-trustees, if there was one trustee and it was clearly specified in the trust what was to happen with the house, what would have happened?
So I would say that you have one successor trustee, and if that successor trustee is not available, then the other sister or the other sibling would be the successor trustee.
But in this case, had they had a single trustee as opposed to co-trustees, and it was clearly laid out what was going to happen with the house, would this have been just expeditious?
Yes, it would have been.
And
It would have been because co-trustees require them to agree.
okay. All right, so co-trustees that's something you want to avoid. What are some other things? I mean, I think what it suggests to me is often families don't talk about the estate plan they created. The parents don't talk with the kids about what they did. Is that a problem?
Right. That is a problem.
And do you recommend to people that you work with that, hey, you know what, go talk to your kids about what you did and why you did it?
Right, right. I think so. I think because they don't talk about that.
And would you say that you see, I mean, we talk about sometimes why estate plans fail, and they fail not because you didn't do your job. Um, they fail because the beneficiaries simply aren't prepared for what sometimes can be a rather sizable bequest. What is your experience there, and what kinds of things should be avoided?
Yeah, so the other thing that you should avoid is the in-laws.
In-law.
So right, in-laws, I think that what I suggest is that you disinherit the in-laws. Because let's say that, for example, you name a beneficiary, your child as a beneficiary, and they get divorced, then it becomes problematic. So you want to disinherit the in-laws. That's what I suggest.
So wait a minute. Let's walk through this for a second. Let's say that, you know, son and daughter are beneficiaries, right? And I
Yes.
think you're talking about their spouses specifically, are you not?
Yes, I am.
Okay. All right. So let's say son gets divorced. Okay. And you're talking after the grantor trustees, or the, you know, the parents who set up the trust. You're talking about after they've passed away, the son gets his bequest and then gets divorced, right?
Right.
Okay. How how do you disinherit the soon to be ex spouse from the bequest that came from mom and dad?
So if you specifically disinherit, then it may, because otherwise it's going to end up very, very messy,
Hmm.
right? Because then the spouse would say that I'm entitled to that bequest because it's community, especially in community property states. So they would make that allegation. So I would say you should disinherit the spouse.
So, in other words, what you're saying is a bequest from a parent via an estate plan can become community property unless otherwise specified.
Yes. So if so in bequest should be a separate property. It's supposed to be separate property, right?
Okay.
But it's so easy to turn that into community property. So
Okay.
to play it safe, just disinherit the spouse. That's what I would say.
Do you see, and I'm sure you review a lot of trusts that were created elsewhere. Do you see where this language and this level of specificity doesn't exist?
Right. Oftentimes it doesn't exist.
Holy cow.
Yeah,
So,
it doesn't exist.
in other words, mom and dad can say, we love you, son and daughter, but if you get divorced, we don't want half of this to go to your ex-spouse in a divorce settlement, right? That may be their wish, but you're saying this has to be specified.
I think it should be specified. So, for example, I did an estate plan, and the mother didn't like the son-in-law. The son-in-law was very disrespectful to my client, but she didn't want to specifically disinherit him. And that is because she didn't want to hurt her daughter's feelings, right? So
Mhm.
sometimes that happens, but I recommend that the client disinherit the in-law.
Wow. Wow. That's a super important point.
I
Uh, what about, and I'm sure you've seen this, where a parent or parents might say, we've got two kids. One of them's doing really well. He's I don't know, a doctor making a good living. The other one, not so much. He's kind of struggling. we'll leave more money to the one that's struggling because he or she needs the help a little bit more. I've seen instances where that's not the best idea. Have you as well? And what's your take on that?
That's a terrible idea. I've seen that so many times. Like, for example, I just recently did an estate plan, and the mother, I wouldn't say disinherited her other son, but the mother, because one son was not doing well and the other one was doing well, the mother gave everything to the one son that's not doing well. And that's terrible. So, yeah, I think that's a terrible idea. I think that the distribution should always be equal.
Yeah, because you got one child who, their response. I mean, you could say, yeah, well, your brother's not doing so well. We're going to leave more money to him. Well, thanks, mom and dad. I worked hard and made something of myself, and this is what I get.
Yeah, you're punishing.
You're
You're
punishing me
punishing
for
the other.
doing well. Yeah.
Yeah, right. And that is not. It's not fair. And I think that. I mean, I didn't tell her this, but I think that that is very unfair, and it causes resentment.
Mhm.
And it's, yeah, you should always do an equal distribution. But I've seen over and over where a child who's not doing well is yeah, so the child is doing well is punished.
Let me shift to one other thing, and that is making bequests before you pass. Let's say, for example, the parents say, when you get married, we're going to give you a gift of 50,000 to have the wedding, buy a house, whatever it is. But we're going to give you sort of we're going to give you your part of your inheritance early if that happens. Okay. And let's just, and I've seen this before where that will happen. One child gets married, and then they say to the other child, well, okay, and they say, well, what if I never get married? Well, if you never get married, we'll just give you that much more when we pass. Okay. I think that's also a terrible idea as well because of the time value of money. Let's say child one gets married, I don't know, in 20, I don't know, let's say they got married 20 years ago, then 20 years later, mom and dad pass, and then they're going to equalize that gift to child number two, but it really should be equalized with interest backdated to when child number one got it. But often that's not specified. So I guess I'm fumbling with this, but I think you understand what I'm saying. If
Yeah.
you're going to give
Yes.
if you're going to give an early bequest to child one, give it to child two right then and there, right?
That's correct. That's correct. But people don't do that. But
Yeah,
they should.
yeah. I mean, because it could be problematic if you have 6 kids.
Right, right.
It's like, wait, I'm going to give a gift to one now. I got to give, and so these are just kind of landmines that people step on. And when you're interviewing people in the beginning, are you helping them avoid these?
Yes, I make suggestions. The other one that's really, really important is guardianship.
Hmm.
So let's say that you have minor children. So generally speaking, the document would, so the guardianship would take effect when both parents are deceased.
Okay.
That's how it's normally done. But I don't do it that way.
Okay. Now,
The reason
I'm sorry. Go ahead.
The reason I don't do it that way is because there was a case where husband and wife were driving. Husband was killed
Oh,
and the wife survived, but she was incapacitated.
wow.
And because she was incapacitated, she was still alive. The guardianship did not take effect. So the children ended up going to foster care. So the way I do guardianship is that it takes effect even if the parent is incapacitated.
Wow. Okay. So there is a right. So in other words, there's a right way and a wrong way to do guardianship. So these are all where, I mean, we've talked about 3 or 4, tripwires or landmines that people can step on. I want to we have a few minutes left. Your practice involves not just you. You also typically engage other professionals for other reasons to deliver a more holistic solution. Why is it important to play this as a team sport?
It is a team sport. So it involves tax situations and also financial planning. So financial planning and tax, it comes into play. It's a team situation. So I promote the 3D asset care,
Okay.
and that brings a team together to it's a holistic approach, not just one piece, right? Not
Right.
just a state plan, but you need to look at the tax situation, and you need to look at the financial planning situation as well.
Yeah, they all overlap and integrate with the other, one with the other, don't they?
Yes, absolutely.
And so, yeah, this is this idea that we're always promoting called the digital family office, which is all the advice. It's nothing more than all the advisors working together as opposed to separately, right?
Right, right, right,
Um, and it's something that we help our partners deliver through their partnership with the National Referral Network. That's what the whole thing is about.
right.
You can access
Absolutely.
the team members you need to access to deliver what you're talking about. Speaking of which, if you're watching this, and I sort of said this at the beginning, hit that subscribe button, okay, which is at the bottom of the screen. We do these every week at this time. Keila, I want to thank you for being here. I learned a lot, especially disinheriting the in-laws. I mean, I think you're the first attorney that's actually spoken at length about that. So really interesting stuff to avoid. We will be back next week with professional insights, same time, same station. Keila, thank you so much for your insights, and we will see you all again soon.
Thank you.